The Financial Mail and AmaBhungane are asking the Western Cape High Court to compel Steinhoff to release the full forensic report on accounting failures and fraud compiled by PwC. The application follows two separate requests under the Promotion of Access to Information Act for the 7,000-page document. Both attempts were refused by Steinhoff, which cited legally privileged information. We're joined now by the attorney representing the Financial Mail and AmaBhungane, Dario Milo. Dario, good evening to you, and thank you so much for your time tonight. Firstly, this case speaks to a number of issues. The first one is really about transparency, and that's what part of what this application is. Why do you believe that it is important and it is in the public interest for Steinhoff to make that PwC report public?
Good evening, Kathy. Good evening to the viewers as well. It's a good question, and it goes to the heart of what the case is about. As you say, it is about transparency. It's about accountability in relation to one of the most significant corporate scandals in our history, if not the most significant in our recent history. And it's about the public having the right through the media to have the details of that scandal available to them. In other words, how it happened in particular. What was the extent of the accounting irregularities? Who was involved? How was it allowed to happen such that we had this collapse of the share price of 98% affecting, most South Africans, because so many pension funds were shareholders, including, of course, the government employees pension fund. So, Kathy, the answer to the question of why the public should have access to the report is based on the fact that this is a matter of great public interest, and the public should have maximum transparency in this context.
Of course, without that transparency, there can be no true accountability, because the public doesn't yet fully know who the individuals who were implicated in that report are.
Well, Kathy, transparency and accountability, yes, they do certainly go hand in hand. And what we say on behalf of the media applicants is that the defense which Steinhoff has put up, in other words, the reason they say they can't make this available to the public in its full form, which is, as you say, 7,000 pages, including the annexures, they say it's because of legal privilege. In other words, that because this report was commissioned with legal advice in mind and litigation being contemplated, that should be a reason that the public don't get to see the report. It would prejudice litigation and so on. We say that on the facts, legal privilege doesn't arise. They say it does, but we say factually, in fact, the report wasn't commissioned for that purpose. The report was commissioned in order to find out what went wrong at Steinhoff. And secondly, we say even if legal privilege did arise, it is waived on the facts because Steinhoff released an overview of the report to the public. And that overview contained the key findings of the report. And then finally, Kathy, our argument is even if legal privilege wasn't waived and did arise in the report, it should still be made public because the Access to Information Act permits, in fact, requires information that is in the public interest in a specific way to be made available despite the presence of a defense on the part of the person who holds the information.
Dario, this case, of course, comes at a time where, the country is really having a broad conversation around clean governance, even within private corporations. And one just thinks about the companies that have been named, not least of which, in the state capture report, at least part one, as not having done their bit to uphold clean governance. So let's talk about the role of ethics where this case is concerned, because ultimately, it's about whether corporate South Africa actually, practices what it preaches.
Well, Kathy, that's certainly a way of looking at it from a non-legal perspective. As a lawyer, I unfortunately or fortunately have the task of looking at it from the lens, and the narrow lens often of a lawyer. From a legal perspective, the answer is this, that while legal privilege, in this case, the defense that Steinhoff uses, is an important value and an important principle, we need to respect legal privilege. That's not the end of the story. There is a balancing act that is required. And if there is information that is of compelling public interest, in this case, if it would reveal the substantial contravention of the law, which is what PIA, the Access to Information Act, requires, then that should be made public. And if it is made public, it will certainly lead to greater transparency and accountability on the part of this particular corporation. So I think that's the way lawyers would analyze the case.
If this application fails, do you have a plan B?
Well, plan B, if it fails, would simply be to appeal the ruling to a superior court, and it may well be that if Steinhoff loses the case, they will take the same course of action. We are confident that the court will consider all the complex issues that are at play and resolve that balancing act, if it gets to the balancing act, because we say we should win the case even before you get there. But if it does get to that balancing act between legal privilege and public interest, we say the facts of this case quite clearly resolve themselves on the side of the public interest and the right of the public to be informed of what's in that PwC report.
Dario Milo is attorney representing the Financial Mail and AmaBhungane. Let's leave it there for tonight.